Welcome back to the House Judiciary Committee, and we are turning our attention to S 195. And I think did we get through your testimony the other day on that? No, that was on S 58. We didn't get through your testimony. So
yeah, have to do either or.
We're looking at an update and
On S58?
no.
Oh, 195.
195.
Oh, we're on 195.
We're on 195.
Okay.
So
Yeah, right.
the hope is that we can hear a bit from Tim, and then we can have a discussion, and we have a couple decisions to make to try to get a version of this bill that we might be able to vote on tomorrow. We don't absolutely have to vote tomorrow, but the sooner we can get it down to corrections, the better, to let them do their work.
Corrections,
So-
is that proofreading?
Corrections and Institutions Committee, I'm sorry, that's right. Yeah. That's,
Which part of 195 are we on?
it's draft number 1.1, 8:49 PM. 4:15 is the date.
One of 23?
Yes,
Draft 1.1.
23 pages.
All right, so we can kind of, if you can comment on the changes that we had on 1.9.
Okay, yeah.
And we have a couple other areas that we're doing some additional work on and would like your input on, given some other testimony we've had. That's particularly the pretrial supervision program, but
Okay.
you can start anywhere you want, though.
Okay, yes. So looking at the 195, 1.1 on page 3,
1.1?
1.1, S195, page 3, starting on line 14. Where we're at here in the process is where the judge is considering the risk of flight in the context of a particular matter. And so the language you've added here is, I think, advisable. I had sent a slight variation on it. I think it largely gets to the same point. I know that Attorney Novgrowski and the chair have a slight variation on the language, but basically the point being that we want judges, prosecution, defense to be aware that non-compliance with court orders and failures to appear should be a part of the analysis when they're considering whether or not to impose bail, to impose elevated conditions. And I think the language that you have in here, there's also a piece in here about whether or not they're on probation, parole, furlough, or other release. This language is very helpful because when you're in I used to have this with like size 30 font when I was first doing arraignments, 7554A1, or having an overnight conversation with an officer, because it just reminded me, and eventually you end up sort of memorizing it. But when you're thinking about all of these factors, these are ones where if I'm a judicial officer or a prosecutor next year, if this became law, I would look at the statute. Oh, they updated this last year. And I would say, clearly they're concerned about non-compliance with court orders, which is, you're talking about alleged violations of conditions of release, as well as the actual failures to appear. What we've seen, because each county has their own judges move sometimes every 2 to 3 years. State's attorneys often stick around longer than that. Sometimes they're moving. Defense counsel moves on and get new contracts. When the statute is more clear, it provides a better diagram of the analysis. And I think that this is advisable language because it gets at the goal that is part of the impetus for S195, which is repeat offenders, which, as we know, take up 60% of all dockets. So you're putting a spotlight on it. And if the point of the bail analysis is to engage people, it's not to detain people, it's not to make them feel like the weight of the government is falling on them. It's to engage them with prosecution, because if we can't engage them, then the cases keep piling up. If we can't engage, we can't resolve. And if we can't resolve cases, then first-time offenders are going to be sitting in the wings saying, my case ever going to get heard? And so this language is helpful, as is, as I testified the other day, the removal of the $200 cap for repeat offense types.
Okay.
60, you just said 60% what?
So 60%, 59.8%, I believe, of all of the pending dockets as of March 1st are related to persons with two or more dockets, meaning 60% of the pending dockets are for individuals alleged of committing repeated criminal conduct. So it's the majority of the docket, pending dockets. And a docket is a case is a docket. Synonyms.
Didn't you show us some stats like that when we were in the joint meeting?
Yep.
And wasn't some of that disputed, those numbers or something? Have we been
There was a
updated on
discussion
that?
about the number of people with 5 or more, 10 or more.
Yeah,
And
yeah.
the distinction is that we see all pending cases as really important to look at. And one reason being you might hear the term active or inactive case.
Okay.
An inactive case includes arrest warrants. So if you were supposed to go to your arraignment here in Washington County and you didn't show up, the judge may issue an arrest warrant. The case is now inactive, but then you show up the next day, now it's active again. So we think that inactive and active put into a pool of all pending cases is the best depiction of the weight on our system.
So you would know that. The judge may not necessarily know that. That's where the difference was.
I think my presumption is they may have been using active only in that given point in time, but I don't know. I would need to look. And that was for people with 5 or more, 10 or more, something like that. Yeah, but I'm talking about all pending cases, active and inactive. Another example of an inactive case is something currently waiting a competency evaluation, which could be a very active situation, as we all know, and those can take some time. So, so I think the language change on page 3 is good.
Angela.
I think, and you just referenced the language change on page 2, right? The removal of the $200 limit.
Yes, and that is as it came over to
Yeah.
the Senate. Yep.
Can I ask a question about that?
Yes.
I don't think that we've gotten to ask, or were you trying to
Go ahead.
avoid this
No,
topic
no,
for now?
no.
Okay. As I read it, the removal of the $200 limit applies to an offense committed by a person who has been released on personal cognizance or conditions. Would it make sense then to not apply, if the $200 limit shall not apply to a person who has failed to appear? Or is that saying the same thing in reverse? Like, this seems like a wider net. The way it's written now, you're applying it shall not apply to an offense
I think,
committed by.
I see what you're saying about offense versus person. So the way I'm reading this change here, and I think legislative council may know the history on it, there was maybe a slight language change, maybe a little bit in the Senate or from a note from Judge Zone, but the way I see it is an offense would be has multiple meanings. So one way that bail may be imposed is overnight. So the offense happens, the officer talks with the judge after talking to us and says, there's all these factors happening right now. By the way, they are already released on their own recognizance, and they've now picked up 5 VCRs. They went to the victim's house 5 times in the last 12 hours. So just so you're aware, they have all these new offenses. So the judge, the way that bail works is that the individual counts. So for example, if you have 5 VCRs, each one of those counts, which would be an offense in this terminology here, you could have $200 applied to all of those. Those are individual offenses. So it is important to tie it to the offense as opposed to the person in the way that it is currently drafted, because as you'll note in this section, you'll see that the unchanged section says, in the event the court finds imposing bail is necessary to mitigate risk of flight from a person charged with a violation of a misdemeanor offense that is eligible. Here, they're tying it to offense as well, the existing language of a misdemeanor offense that is eligible for expungement. So this updated language is also tying it to an offense and just saying, okay, the presumption existed for the initial offense, right? But the presumption is going away because now there's a repeated incident, which is an artful way of just saying they're currently pending and they have conditions or recognizance already upon. So I think the language is fine as written, but it could apply to a person with multiple offenses that happen. That makes sense. Because bail is imposed related to alleged conduct not imposed related to persons, even though it deeply affects them. It's sort of legal jargon, but yeah.
Or dehumanizing, for sure.
It's part of it is that in prosecution, we are not, we always talk about it is we're talking about alleged conduct that is prohibited. We're not talking about persecution of persons. So yeah, I would say it's an accurate way of describing how the system is functioning or not.
Okay.
Karen and then Joe.
Since we moved over to this section, I'm curious. So it sounds like you support the language that's there, that's listed. We've heard from others who do not support the language that's there. Can you remind us why this is needed? Why?
Yeah, so
From your
talking
perspective.
about the context that we're in, given that the presumption of the $200 limit, which was a change from 2018, before that, there was no $200 cap for misdemeanor offenses that were eligible for expungement. Now, for was it 6 years since that time, you're talking about an amendment to it. So it still has the cap for the initial, but it's for the folks that are coming back in. It's in my opinion, to treat the way that we should be using bail and conditions, which is to look at each case. How can we engage this person? And the point of bail never to detain, it's to engage. I have had numerous cases where bail was imposed and the person could afford the bail. And the point always is to engage them, to avoid them not engaging. And so this, I think, still allows for the presumption. And it has a slight update to account for the fact that our system is currently dealing with the majority of our dockets being those with repeated offenses. And so a judge can more accurately assess. Maybe it's $50 the second time. Maybe it's $5, right? You don't need to impose $200 or more. It just allows the judge to not think about this cap for a person with repeated offenses. In my opinion, it allows for a more fluid, specific approach to each individual that comes before a judge who has more than one pending docket. Because that's what we're talking about, a person with more than one pending case.
You mentioned the cap that they could pick 50 or $5. They could do that now. It can't go up. So that's the piece that I find concerning, is that it's increasing it over there to folks who maybe aren't going to be able to afford this. And I feel like violation, like adding other conditions or some of the other tools that we're putting in this bill are potentially going to help. So I feel like for me, I'd want to see how those tools work before I potentially put financial.
I mean, with any condition, the way that a certain member of the Vermont Supreme Court has referred to conditions is the paper tiger. So it is a piece of paper. We do not supervise 100% of pretrial individuals. You might now be supervising some in here, which is something we'll see how it turns out. And what will be interesting is there could be certain persons in that pretrial supervision population that at one point had bail imposed. They showed up to court, and the way that it happens in the huge majority of cases, the bail is imposed, they are arrested, usually for failure to appear. They show up, the bail is struck, right? Particularly for these small amounts. The point of it is to engage. It's often a temporary tool, which is why when we're looking at cash bail, and I always, in Department of Corrections, if they're listening, would remind me, when we're looking at cash bail, it's always just a snapshot. The very minute after you take that snapshot, someone could have posted bail, the arrest warrant goes away, et cetera. So for me, this is a more, it's sort of a balancing act from 2018 to 2024. We're still allowing for this presumption for folks who have the first time instance, and someone having bail imposed them for a first time misdemeanor expungable offense be exceedingly rare. We're going to, the recognizance release on your own, recognizance is the presumption. And that's in our bail statute already. ROR is presumed. So at every single arraignment for every single person, the judge reminds everyone, ROR is presumed. Prosecutor, why should we impose conditions? Why should I consider bail? And the defense may argue, well, recognizance is good here. The person has no prior interaction with law enforcement, et cetera. And then then the judge is like, oh, that's true. There's no prior interactions. They've always complied. Let's say that they had prior interactions. They've always complied with court orders. So that's the presumption is still there of ROR. And sometimes we say that. And oftentimes when I was doing the arraignments in Washington County, I would look at a case and say, oh, a person fled from the scene, a DUI, oh, I'm so worried about it. They show up, I see the person. You know, that's one of the great things about arraignments. You get to see human beings. It's not virtual. And you look at the person and then the defense attorney and you see their whole families in the back of the room. And you say, you change on your feet. And that's what I appreciate about 7554 analysis. It allows you to be fluid. And this would allow, these prosecutors are never imposing bail. We're sometimes asking for bail, but it's a judge who could now say, and the example I gave the other day, I'll stop picking on Keston, but the example I gave the other day is someone with means having $200 imposed on them as a limit can be inequitable in some circumstances. And you're supposed to consider someone's financial circumstances when you're imposing bail. It isn't determinative. Doesn't mean that you can't impose bail that they cannot afford, but you're supposed to consider it. But the Supreme Court has been clear that you can impose bail that a person cannot afford because the point is engagement, never detention. That said, I think that this tool, my perspective, is that it will allow for a more concentrated engagement for individuals that have come back to us in the court system. And it will allow a judge to make that call in each case. And these are the, we're going to come up with a different word for tools, but it's April, someone's going to say it. These are the tools we have to engage folks. And so when we hear community members, Tim, okay, this person has 15 VCRs. How did you allow the judge to impose $200 on that? Well, that's all the judge can impose right now because it's an expungable misdemeanor. There's confusion in the public about what we can use bail for as well. But this would allow a judge to consider a VCR could be as benign as acts, VCRs can be fairly benign and they can be very, very serious. Someone that is stalking someone standing outside their home, that's a very serious VCR that can cause deep, deep pain to the victim who's just trying to live their life. From our perspective, 15 VCRs for going to the victim's house, incredibly serious, and it shows a lack of respect for the court process. Combined with failures to appear, a judge can consider all of that as saying, you're not getting it. And for you to get it, we're going to impose new conditions and we're going to, let's just say $202, right? The arbitrariness of the $200 as someone picks up more and more charges to the public and to some prosecutors feels like a bit of an absurd exercise because we're talking about $200 that was set in 2018 as a limit. Doesn't mean it wasn't well intended. It just means that in 2024, knowing how many repeat offenses we've had, that it feels like we should do a balancing act. Still keep it for first-time folks, but for future folks, let's think about whether or not it's appropriate.
And so I appreciate all that, and I hear the intention in it, and I guess I'm still, like, a judge could just say, I'm always going to start with $50 bail, and then that gives you room to go up with it. So I hear the understanding of it. I'm just wondering if we have really utilized this in the way that we could before we go ahead and throw it out the window. So that's the piece where I'm stuck.
Yeah, and I think I did a schematic at one point during, I forget whether it was in this committee, but often what we've seen is the first failure to appear, you get a judicial summons or a cite and release. The second one, usually maybe less than two, like maybe, oh, let's try rescheduling the person. They have another case next week. There's a lot of effort that I've seen very compassionate judges do to exhaust all options before exercising the bail option. And it's very rare that on the first instance that bail is imposed, unless it's a really serious case. Right. Someone with a tractor trailer, DUI, they fled the state. Okay, there's some serious stuff here. They're basically driving a lethal weapon and they had a DUI. So, and we're concerned about them leaving the state on a regular basis. There was a recent, unfortunately, very serious case in Moortown about an individual who was involved in an 18-wheeler accident where a woman died. And in that situation, the individual was held on substantial bail because they were driving through Vermont in an 18-wheeler. So it's unfortunately, we actually put that in the hypothetical in this conversation last year about a person driving through the state with an 18-wheeler. And it ended up, unfortunately, being no longer hypothetical.
Joe, jump question.
Yep,
Karen, you're done.
I'm done.
Yeah.
Yes, thank you.
the Defender General's office has asserted that this is problematic because it
ties the value of the imposition of bail to public safety and not to risk of flight. And I was wondering if you had a response to that assertion.
My response is to quote Judge Zone in summary form, which is that basically in 2018, prior to the $200 cap, apparently at that point, right, would the same thing have been alleged? I don't know, right? We're going back to a version that isn't full 2017, but it's like 2018 with a slight wrinkle to it. And the only constitutional purpose of bail is to engage them. It allows for the cap to be removed. I have a completely different perspective. And I don't see any reference to public safety in this subsection or the section above it. So because the point here is to, and you're looking at the 7551 here, is risk of flight, if that's tied to bail, has to be about engagement with prosecution and flight risk. So it can't be about public safety alone. Now, as we know, seriousness of the offense could lead to someone wanting to flee. And that isn't a public safety basis on its own. It's a part of this risk of flight analysis. So I would respect a different perspective.
Great, thank you. That's helpful.
And I'm sure Judge Zone, he had made a comment about it in the Senate conversation. I think the same topic came up, and I am probably inartfully summarizing this point.
Ellen,
I think Ken had his hand up.
So, Tim, just going back to that $200 limit. Was it me? I'm sorry?
No, go ahead.
That, I think what I heard you saying, I'm kind of looking at this differently, I think, from others. You're looking to use the $200 as kind of a teaching moment to get that person in court, set eyes on them, or get them in a room, set eyes on them, and evaluate the situation, see what you're dealing with and stuff like that. Maybe like a teachable moment, maybe, and it could be life altering to go and set this person on the right way. If they're shown, hey, we're slapping your hand a little bit, you're getting your $200 back for the most, if you show up, right?
Or you're right, often the way it works is that the $200, let's say it's during business hours, like during 7:45 to 4:30, $200 arrest warrant issues because they didn't show up. They're arrested and brought to court, and the bail is struck. The point in that circumstance is what I'm deciphering is immediate. What's nice about it happening during business hours is we can immediately engage them. And that's the point of bail, is to engage them, to get them to come before a judge and really recognize that whether it's, a misdemeanor domestic assault or aggravated assault, these are cases with victims. These are cases that clog our system when we can't resolve them. And the nice thing about when someone comes to court, whether it's because they're coming on their own or because they've been arrested and brought in, is it's an opportunity. Once we get that person in front of us, defense attorneys there, the amount of judges that have looked at prosecutors and defenders saying, hey, guess what today is? Today is the day you make a plea agreement happen or not. But we have the defendant here, we have all the parties here, let's get it done. And that's often can happen on an arraignment day if people are motivated. But the other opportunities when someone is arrested and brought to court, or they show up for a future status conference, it's an opportunity to resolve things.
So when we were in COVID lockdown, for lack of a better word, right? I assume our backlog probably got worse because we couldn't do the eye to eye, watch body movement, observe everything. And now you can. So we're much more in tune with what's going on with that individual to try to help. It's not all about throwing everybody in jail and all this stuff. It's like, we're trying to help. We're trying to set them in the right path. It's like when I was a younger kid, well, even now, when I do something bad, I'm probably still reprimanded. So
I can attest, I've never seen you in court. So, but I think that's right. It's really such an opportunity. And one of the parts of the job that I think is the most like social work, right? When you're able to work with a defense attorney, look at the person's circumstances, figure out a way to sort it out, which could be a restorative justice referral. And by the way, for the expungable misdemeanors, there's a long list of them that we are sending presumptively to diversion anyway. It's just folks that are not engaging. Yeah.
I was just going to say, it's kind of like a diversion thing, right? You're dealing with that person, and if you follow the steps with a diversion, we're going to hopefully set that person on the path to having the citizen.
I've had cases where there's been cash bail imposed, the person comes into court and they're referred to diversion at that point. So it's not, diversion is an option at every single, there's no time where it's not an option. Moving on to the, sorry.
Ella, and Ben, did you have something
I'm gonna
else?
save it for when I'm in the chair.
Okay.
Ben, you want to speak? Please switch. No.
Yeah, thanks. I mean, I just haven't had time to really dig into this, and I wasn't around when we hadn't changed it in 2018 and added this. But so I'm just trying to understand. What I'm hearing from you is that this would be particularly useful in situations where people are coming back in for the second or third or fourth or fifth
Or 74th.
or 74th time of the same kind of offense in particular.
Expungable misdemeanors, yeah.
Yeah, and maybe I'm not hearing you right, but I'm imagining the fifth retail of theft or maybe more importantly, something like stalking but when I'm or in situations where they have been not showing up for things in court. But I read this as much broader. And so I guess an example I'm thinking of is somebody who one time got brought in for retail theft and is still waiting 6 months later for their court date or something and has shown up when required. And now they got picked up for, having a little bit of an illicit drug on them and as a user. And that doesn't seem like the situation in which you'd want to be applying a higher
Yeah.
bail.
I mean, if they're showing up, there'd be
Yeah.
no basis essentially. If they're showing up, then.
But
yeah.
those guardrails aren't in this. And so, again, I'm asking, is this maybe broader than your intention? And if we were trying to get at your intention, could we be more narrow?
So in part of looking at the broader statute that we're located in, the analysis about when bail can be imposed, noting that in my observation, judges are exhausting everything for a misdemeanor offense. The only circumstances that we've seen, people are not coming in to arraignment where they're actually showing up and they're like, hey, I'm here for my arraignment for a retail theft. So they've shown up and they're in front of the judge. And let's say they have another one pending. The judge would potentially have an issue, right, on an appeal, on a bail appeal, if the sole basis was basically two pending cases. Certainly the judge would have to consider all of those pieces, flight from prosecution being the point. It isn't that they picked up another, it would still have to be tied to the flight analysis. It couldn't just be that they have two pending cases. It would have to be, well, and you have this other serious thing pending, you picked up this one, and you have 10 others pending. And you're not respecting any of my conditions not to go back to the same store. And the way that it's sort of built in is it's this analysis. And what we're doing, I think, here is balancing the presumption that you provided in 2018. But if they come back and the judge goes through that whole exhaustive analysis where they're doing the flight risk and the person doesn't show up, for example, that's just one of the major things. Not showing up and non-compliance to court orders are the focus, because those are the pieces that we have been very frustrated with someone. Okay, we've got this person, they're not showing up. And clearly we need to get them to show up here to sort out this case. And so this gives the judge a more customized ability to do so in certain circumstances.
But I think Ben may have something to add on this also.
Yeah, so for the record, Ben Novogrosky from the Office of Legislative Counsel. So this is related in a way to something that this committee has asked to be changed already in this bill. So the explicit conditions are factors that need to be considered in bail, as passed by the Senate, were initially tied to conditions related to protecting the public because they were in that provision. There was testimony by Attorney Leaders Dumont, by Judge Zone, that oftentimes it's really hard to distinguish between conditions related to bail and conditions related to protection of the public, because oftentimes they may have dual purposes. And oftentimes judges kind of conflate the analysis altogether, and it's hard to really distinguish between the two. And so as this discussion is going on and hearing the sentiments of the committee, that's something that you could do, is that, you could potentially tie this to conditions related to bail, but I think it would run up against the same issue that this committee has already addressed in another portion by removing language that was tied to a specific type of condition. Does that make sense? So the committee is almost discussing doing what it already changed, which is in another provision of the law. So from a drafting perspective, it can be done, but the committee can nothing's been decided because it still hasn't been voted out, but has at least made a policy decision to remove certain restraining language in a different part of this bill. And now it's discussing putting it in potentially in this provision. And so I want to highlight that for the committee because it's a little incongruous, that word, to kind of do one without the other. So from a drafting perspective, it could be done, but there were practical implications that were considered in another provision that the committee chose to do something different.
Can I clarify?
Yes.
So you're saying if we did remove this, it would be incongruent?
No, so if you remove the statute or the new language altogether, it would just be the current law. But I think what Representative Chapin and that's sort of what you were getting at, Representative Dolan, is maybe putting some guardrails to make sure that it's tying it to conditions related to bail, because that was a concern raised by the Defender General. My point is that could be done, but I think it would create the same issues that this committee addressed with those other factors later on in the bill.
So it's leave it or take it out?
It's ultimately a policy decision, but I want to flag the considerations that the committee has already dealt with
Okay.
that are some.
So, while we're on that one still, I will be asking whether we want to leave it or take it out. But let's keep going with Tim. So let me ask, I'm sorry, you had to, okay.
It was on this topic. I don't know if you were switching to a different topic.
I was going to, yeah, go ahead.
Well, and I don't know if this goes in the guardrails that you're talking about, Ben, so I feel like I just barely understand what you're saying. Nothing to you, I think it's my brain is, I, like, my gut is saying I don't like it and I would vote to remove it. And I want to be open to meeting what I'm hearing, the state's attorney saying they need. So I wouldn't see it as a guardrail, but you're saying it's after this multiple times. It's like you're not getting the message. So could we put a number? So it's like at the fifth offense, or I don't know, something like that. But I don't think that interferes with what you're saying.
So,
I feel like that would be a compromise that I could at least explore. Otherwise, I'm like, get rid of it.
yeah, well, I've always kind of thought not to continue on this one, but since we're moving on and have lots of other things to do, that why wouldn't it be tied to the fact that this person has fled? You know, you fled once, now you don't have the $200. You still have to look at the ability to pay and all the analysis and stuff, but you have fled once and now that $200 limit doesn't apply. What?
I would want a more exhaustive understanding of how flight would be. Would it be a failure to appear? Would it be any failure to appear in court? Because that's from our perspective, that's fleeing. I mean, if someone is not showing up at a court appearance where a judge who is been appointed, right, it'd be a flight.
That's part of it. I mean, yeah, the presumably the person who comes in and says, my car broke down it's a discretionary thing. I don't want to mess with the flight from prosecution definition and need to say willful non-appearance, because I think that's picked up on in the normal process of what the state's attorney is going to ask for and what the court will provide. But it's like, you fled once, you didn't appear, now you're subject to this. Although there's going to be discretion on whether, they're going to go through the normal process of figuring out whether to set bail, right? Anyway.
Yeah, and the one issue, I wouldn't advise that, and not because I don't appreciate the intention, it's because of, for example, and I'm always saying this in here, but it's the middle of the night. It's not like the wonderful, pre-scheduled arraignment where there's a lot there, you're talking with your attorney and it's a Thursday morning and the sun is shining. I'm talking about the 3 a.m. analysis for someone that has multiple pending situations. And it could be that the first time that they've come back is very serious. For example, person, because of the ROR requirement, as a presumption, let's say a person has, let's say a person has a disorderly conduct that we could have charged as something else, but we charged it as disorderly conduct. And it relates to activity that took place in front of a business in a downtown. They're doing something that it's a disorderly conduct. They were engaging in fighting and tumultuous behavior right in front of a business. And let's say it was sort of directed at a business owner. Business owner comes back the next morning and the person is there again, is actually blocking the entryway, and they have express condition. Do not go within 300 feet of that business. In that circumstance, the person is then being combated with police officers. They're picking up multiple counts in that second interaction, including VCRs, simple assault on a police officer. This is not an unheard of situation. And in that circumstance, having the police officer call the judge and saying, we're concerned about this person showing up for their court appearance in the morning. In that situation, the judge could say, I'm also concerned about it. We just imposed these conditions. We just said, don't go there. Now they've picked up a brand new slate of charges. And let's say the person is a person with means. Let's say it's one of the people in this room and they have the ability to pay $200 and the judge is very annoyed.
Remember, we're legislative pay.
That's exactly legislative pay.
Would not be in this room.
Right. No one in this room.
One clarifying thing, just to pause it.
Yeah.
If they assaulted an officer, they'd be able to be charged for that. And then that could be something where you could have higher bail. So I guess I'm not going for the significant piece of it.
Let's
because
just
if
say 5 VCRs, no simple assault, just 5 VCRs. In that circumstance, a judge being able to say, you didn't get it yesterday and you need to come back in, probably strike the bail in the morning, but we're going to do $1,000 because what the heck? In that circumstance, the judge is going through that analysis, that flight analysis, and they're probably striking bail in the morning if they show up and they're engaging, et cetera. But from my perspective, just viewing it as if they have fled in the past, sometimes we're missing an opportunity to engage them more quickly, from my perspective.
Yeah, so I mean, so it's saying that if you've picked up additional charges, you're more likely to flee. I mean, that's what.
That's part of the flight analysis.
Yeah, so you're doing the risk of flight. Well, it seems to me that we either change it to you've fled once or this is going to go. Just my reading of the room. And if that isn't helpful, we'll take it out and see what happens when we send it back to the Senate and have further discussion. And unless there's other ideas of.
And looking at, just thinking about when we're looking at the words being used here in subsection 2, risk of flight from prosecution, it's self-referencing to that 7554 analysis. And so the judge is going through that seriousness, number of the offenses, et cetera. For them to actually find that bail is going to be helpful to get them to engage, they are going through an exhaustive approach that is, if bail is imposed, there's an appealable right to the Supreme Court where they're detained. So in this circumstance, I'd say some of the protections are built in.
No, I understand. Let me throw something else out because I'll find a way for it because this language is not going to work. So if an individual has violated a condition of release that elevates or demonstrates a higher risk of flight than this limit. And I don't know if other people would agree with this or not. So I'm tying it to, not to the additional charges, but something to show the likely, that now there's a higher risk of flight. This is somebody who's already been in front of the judge. It's not that they have a new charge, but it's that there's this now we have proof that the risk is higher. Does that make any sense? I don't know that works, frankly.
I would say, and when I hear violation of conditional release, I think about a conviction. And I think what you want to do is if someone were stacking up VCRs even with no convictions, and I would say non-compliance with court orders and failures to appear, just like we're talking about in the underlying analysis, that we want to include that language. I mean, for me personally, the nice part about this is that you're changing a binary aspect of the current analysis. This person's currently pending. Okay, person's currently pending and they picked up a new charge. Now I can consider in a more unique fashion what to do with the situation. If you were to do more of an analysis approach here, where it's like a weighing of the non-compliance and the failures to appear, it's less binary, and in that way, it may be less clear for judges about whether or not they can impose more than $200. If that makes sense, it may provide less clarity about if they're in the zone of 200 plus.
So we're gonna give this a little more thought and time.
My advice would be to keep it as is.
Yeah, I understand.
So you hear me.
And for numerous reasons, this isn't gonna pass out tomorrow. Because we have a hard stop at 4:30, or at least Ben does. But let me, I'm gonna ask you a couple pointed questions to see if I can advance what Ben is doing for our next draft. And the next question I have is that language that we have for A1, we were also planning on adding it back essentially to B2, have it in both places. Any objection to that?
And B2 is getting back to my, and I'm just quoting the Supreme Court, so I'm not disparaging lowly conditions of release. But we're not seeing issues with judges struggling with the analysis about imposing conditions of release. Judges do a fine job with that, and oftentimes we're stipulating to conditions of release. And the issues that we have sometimes seen is really with engagement with persons who are on conditions. So we haven't seen an issue with imposing conditions.
But that's where it was before. We had that language and we moved it from there back to A1. And because that language is pretty much the same, except for not having that additional language, we thought it would be a little odd to not have it
In both places. So it would be in
both places, to make clear.
It wouldn't be swapped out. Yeah, well then, no, obviously, as long as it was remained in A1.
Yes, yeah, absolutely.
I have no objection. I think we haven't seen many issues there. So is it A2?
Yeah, sorry, I didn't catch all of that. So.
So the same language is-
Two factors, you want that also in not just A1.
But in B2 where we moved it from before. So in both places.
Yeah. Okay.
Got that? All right.
And then there was some language that you wanted added or potentially added to that where right now where it's listed on line, beginning on line 17 on page 3, that and whether in connection with the criminal prosecution, the defendant is compliant with court orders or has failed to appear at court hearing.
Right, it has failed, is what we're changing to there. All right, I'm jumping ahead to page 13. And you'll have another opportunity to weigh in on this, but I just want to try to get.
Yeah, as long as it remains in A1, I think.
Yeah, so I'm jumping to 13 in pretrial supervision and have a couple questions.
Okay. I'll draft 1.1.
Yeah. Yeah. So we've had a couple times concerns raised on whether 5 pending dockets is the appropriate first hurdle to go over. And just so you know, this language is going to change a bit. And I'll explain that and get your input on this first, and then I have a second question. So the question is, so what we're talking about doing is having the following. That the first question is, did the person violate conditions of release pursuant to section 7559? Or does the person have at least 5 pending dockets? If one of those checks off, you go to the next question, which is, did this person pose one of these 3 risks? And those are like the eligibility criteria. And once you get there, and we're going to add back under procedure, a provision that makes clear that the court has to do that analysis. Once you get there, then the question is, then the court looks at what I'm looking at page 14 to 15 on D2, would go through that analysis to make the final determination on whether the person should be put into a supervision program. Did you track that?
I think so. I mean, one thing as a
Only making sense to me because
as a goal that when I was thinking about this in House Corrections the other day, if the goal of the pretrial supervision program is to be swift, then the opportunity to have someone be potentially a part of this program, the earlier that can happen, and with the simplest hurdles, the better. So, and without looking at all the different subsections, I don't know if anything has made it less simple, but.
So,
yeah, go ahead. Yeah. Ben.
so basically you would take the like someone that has violated under 7559, or someone that has not fewer than 5 dockets is sort of like the threshold.
Okay, I'm seeing
And
this
then,
now.
and then you do sort of the appropriateness analysis, which involves posing risk of flight, non-appearance at court, or pose a risk to public safety.
Right.
So the eligibility threshold is or there are 5 dockets, or you've violated conditions under 7559. And then you do sort of the additional non-appearance, risk of flight, risk to public safety analysis to determine whether or not they should actually be placed.
And who's doing the analysis? Okay, about whether or not they could
Based
go.
on recommendations
Okay.
submitted by DOC. So in this process, that's sort of the evidence-based screening part. DOC engages that, submits a report.
Okay.
Or
so
the court can use that, cannot, it's just a consideration.
Okay.
That's, I think.
So,
Yeah,
and you'll get to see the language. I just wanted to run the concept by.
Yeah, I mean, overall, the way, and I think you want to pause for a second. You've done a good job of actually, in some parts, simplifying this bill. It was like twice as long, and I think well-intended, but I think you've now simplified it and you focused it on some pieces. So to the extent that you're honing in on having a population of people in a new supervision program, that's totally a policy call that may have budget impact. Certainly, as you all know, there's other portions of this bill that we were just talking about that don't have budget impact, which may actually alleviate aspects of the system. This is one where, as I said downstairs, if people are on supervision, there may be more violations of conditions of release because people are being supervised who we know have already either violated the condition previously or have 5 more pending dockets. Therefore, we may be in a position where, in the effort to have them have better compliance with court process, we are filing more violations of conditions of release. And so the effort to increase accountability is not necessarily always aligned with not exacerbating the court backlog.
So, and we're not just looking for accountability. And the purpose of the pretrial supervision program spelled out as far as strategies to improve pretrial compliance, so we'll hope that that'll work. Besides, there's not going to be any money for this year anyway, from what I'm, hearing.
But yeah, I'd say what you're doing is you're expanding the list of things that could help, like you were saying, Representative Dolan. Maybe this is a great program for somebody that really could benefit from it. And so I think expanding the list, making it nice and simple so that it could happen quickly would be the most important thing, because what you don't want is, Attorney Novogrousky and I have talked about, you don't want to have a bunch of hearings for something that's, not gonna work out. So simplicity is a goal.
So Ben.
Yeah, I mean, I don't know if this completely solves that issue, because this could be done at arraignment or at subsequent, so the way it could play out in my mind is this is something that's proposed by a prosecutor or defendant or the court
right? Okay.
at arraignment. Then the court would say, okay, we want to explore this. GOC,
Go do the analysis.
do your analysis.
Yeah.
We're going to bring you back once that is received.
Yeah.
I don't know how it could really happen otherwise.
Right. So you can't just be ordered on arraignment day, you're in pretrial.
Yeah, I mean, and that's sort of, I've testified that there's a little bit of a clunkiness to this procedure. But think about it almost like home detention as far as what the procedure is to get to the determination. It's kind of similar.
All right.
So there'll be a future hearing where, after they have the DOC report, then they could be imposed. Okay, I'm just following it. Yes.
So I have one other question on that one, and that's, we've had a couple times suggestion that it shouldn't be 5 pending dockets. It should be a little more nuanced. Should it be 3 pending listed crime dockets? Or are you comfortable with 5 pending dockets? Or should it be higher? Why 5 pending dockets? You have a preference?
I think the reason that came up downstairs was that it was like 700 people or something like that with a pending docket with 5 or more. So it was less than 1,000 people. But it is just a call about, we've seen over the last quarter that number hasn't shifted that much in terms of the people with 5 or more dockets, which I think I put up on the screen last time. So if you had it with 3 or more, be a larger.
Well, if it was listed crimes.
Well, and then when we get into the issue with enumeration of what's listed and what's not, I would
So,
say.
yeah, that's complicated.
Yeah.
Well, my feeling personally is that we capture the seriousness in the criteria that is in current D2.
Right.
A game that like it could get.
But there's geographic disparity, or at least there's judge disparity on how they will do that. But I think that's.
Five or more, I think, helps with a population that we know that we've seen them now more than, I mean, if you think about it, if you're a judge and you've seen the same person 5 times or more, that could represent 20 or more or something like that.
So I'm confused because is it 5 different times or is it 5? Because it could be you saw one person once.
5 cases, isn't it?
Yes, five cases or more. Yeah,
Which would mean 5 different appearances.
it could, yes.
Because if it doesn't,
But it could mean more or less appearances. It could, yes.
so given that we were hearing from folks who were in favor of what the cases were rather than number, we don't want somebody trying to game the system, for lack of a better word, and charge more, like break it out how they charge it so that.
There would be no benefit to a prosecutor breaking out this to get them in pretrial supervision. It's just an option for the court to get them to engage. I can't see a single benefit to having.
Okay, I just wanted to.
Yeah, and the other side of that too, Representative Rachel, is that it's just eligibility. It doesn't have anything to do with being placed. It just makes you eligible for the conversation.
That's a great point.
Thanks.
Eligibility is the point. Yeah.
So I had one other question, and then if Angela has any other on this section, on page 16, line 8, we're inclined to get rid of the for not less than 90 days, because if somebody's complied with all their conditions of the pretrial supervision program in a week or 3 weeks or whatever, because the condition was that they were going to, they were subject to a condition of treatment or whatever, then it shouldn't be a requirement that it has to be at least 90 days. It has to be that they've satisfied the conditions.
Yeah, and that would be a DOC call,
Yeah. So
discretionary call. I am, so you're saying line 7 there, a defendant who complies with all conditions of pretrial supervision program, and the compliance would be as judged by a DOC staff member, right?
No, not really. It would be at the request of the prosecutor, the defendant, or on the court's own initiative that they may be reviewed, and the court may issue an appropriate order in accordance. I mean, it's going to be partially informed by any violations that are reported, because they notify the prosecutor and the defendant to the best of their ability, but ultimately nothing is done unless it's initiated by the party or by the court.
Yeah, the 90 days, I don't really have any opinion on that.
Okay. Did you have anything else in that section?
A thought about something that you said, Tim, about there may be more violations of conditions of release with the introduction of the pretrial supervision program, and it makes me think about I've heard, I think there's probably some data about this that say in the corporate sector, when sexual harassment in the workplace became a thing that people were finally acknowledging and then training on, there was like a spike in the instances or incidents of sexual harassment in the workplace. But it wasn't because they did the training, it was because people now knew what to look for and to report. And that's a good thing, because you're capturing more of the behavior that you don't want and hopefully changing that trajectory. So I think of the pretrial supervision program as perhaps ideally having a similar impact where, folks will be, it is supervised, which, has its own drawbacks, but with an effort to engage in that supervision. So hopefully, the idea of engaging with the court and the process of their own defense. I hope that this will be that engagement as well, and maybe they will be connected to services that help them remain engaged with the court process.
Well, and I think one of the points you're getting at is if someone does really well in this future program, it would be a really excellent thing for a prosecutor and a judge to consider during the disposition or resolution of their cases. I can't think of a single prosecutor that would not think about how did the person do when they're being supervised on this program? And it would be an important thing to consider if they were eventually sentenced to, because it would be mitigating something else. And that's it also could aggravate too. If they were a terrible person to supervise and had no respect for the DOC person that was spending their time trying to help them, then it could aggravate things. But it could result in more violations. It could also be that people are like, oh, I'm now being supervised. I'm going to cut it out.
Right, or maybe
Could be either or.
Yes, or the reasons that they were violating their conditions the underlying reasons might actually be addressed through the services that they're connected to.
Right.
Which, and I bring that up to contrast it against the other tool that we were speaking of on page 2, and the removal of the $200 limit. And I'm reminded of the testimony we heard that the bail amount it's shown to be quite disconnected from or ineffective in trying to actually engage folks in the program.
I think the CRT report said it's no less effective, conditions or bail. It didn't say that bail was not effective. And anecdotes are not advised in many circumstances, but I would be lying to you if I told you that I have not seen that bail has assisted in engaging people that have really struggled to engage. And then once they're in, we can resolve everything and get it done. But I hear what you're saying. It's like this would be expanding the opportunity to exhaust other options. And if someone then struggled on this and they got kicked off the program and they weren't showing up at court, then that's maybe when a judge is thinking about bail.
Right. And I think that this represents a more holistic approach than simply kind of turning the knobs and dials and saying like, yeah, more than $200 here for just, that feels more arbitrary, even though I'm sure, I know arbitrary may not be a fair characterization, but it feels more arbitrary than this, which feels more rooted in like a holistic approach. That's my.
So I know Ben has to take off. But we'll just go through the last few things. Are you good with the new 7559 and 7559A?
Yeah.
Okay. Going to page 21, line 3 and 4. Suggesting a possible change to any violations of conditions of release by the defendant proven by a preponderance of the evidence, and then striking that are established by reliable evidence.
This is in the sentencing alternatives.
Yeah.
Determining which of the following are the court.
And there was also discussion about adding not just violations or compliance with. That was a previous point that was brought up.
Violations.
So that either side, I think that was a policy consideration.
Right, that was a previous version. I didn't carry it over to this version, so, okay.
And just a question, I know you have to leave, but what was in the underlined portion of line 3 there? What was there before? Is that completely new language?
Completely.
So before it just stopped at treatment, the need for treatment.
And the risk to self, others, and the community.
Yeah, I mean, for me, I would use the case law language and say, non-compliance with court orders and failures to appear. And that way that's what the Supreme Court has consistently talked about when they talked about violation. Because when I hear violations of conditions of release in statutory context, I think about a potential conviction. And if we don't have that conviction, then the violation is still alleged.
So we can use the same language where we've also made sure it's narrowed to a criminal case at
Non-compliance with court orders relating to a pending criminal matter. Yeah.
But we're also adding proven by a preponderance of the evidence.
That I would need to think about more, but
Non-compliance with court orders.
Yeah, we have some language that we've dealt with earlier. if you
Yeah,
recall. We'll
yeah.
just have to track that down. And so my plan is to have a couple of us swing by and talk sometime tomorrow. We're not going to get this out tomorrow,
Okay.
and we have them scheduled.
We have rescheduled, but I've already kind of started on a draft.
Yeah.
So
So we may have a chance. So, all right. So I want to give folks an update on some developments. So we do have a an amendment on 209 from Jim Harrison, if folks hadn't already heard that. So what that would do is it would allow municipalities the decision of whether to ban firearms. There will be another amendment possibly brought by me to ban firearms at municipal buildings, period, statewide, where there won't be a decision locally. And there's a couple of reasons for that. And by the way, I've already looked at Bruin, and government buildings are included as.
Can we just go back to Harrison's for a minute? Is that all Harrison's looking for?
Well, he wants, well, it's not all, it's much, his plan is actually much more complicated than just having a statewide ban, which I can explain in a minute, but I just want to explain why now, why do this? First of all, lots of people think this is a good idea. So do I. The reason that we didn't do this is there wasn't time. But I am hearing that there's going to be a little more time than we had hoped. Just, I haven't heard, have you heard if it's official that the morning committees are shutting down in 2 weeks as opposed to next week?
We haven't heard that 100% official, but
There's all signs point.
that is what we believe is the case. Is morning committees are actually extending their
Third.
schedule by an additional week.
Right. So that actually opens up time that I have not been planning
So
for.
morning committees
for
might
the-
go another week? Is
Yeah,
that-
for the past 4 weeks, I've been planning that. Actually, I thought this was going to be the last week of the morning committee. So we have 2 more weeks. So
Right.
that frees up a time a little bit. So that's number one. Number two, I thought actually Jim Harrison made some good points as far as you're going to have sometimes a municipal building acting as a polling place, no firearm or no dangerous weapons. And other times it's going to be, it's going to be back and forth. So let's ban it. It's a sensitive area. I'm going to suggest, at least what I'm going to suggest is that for that it's just firearms, not dangerous weapons. Whereas for, the polling place, I think it should extend to dangerous weapons. So we'll consider that. We'll look at Jim Harrison's amendment as well. But we will be for an additional reason, we'll be asking for postponement for third reading of the bill we'll have to decide Tuesday or Wednesday of next week.
Wow.
Because we need to take testimony, and Eric's not here tomorrow. Eric, our legislative counsel on this is not available. He has to be away. And in fact, they delayed Prop 4, which is down in the Senate, because Eric is not going to be here tomorrow. So that's kind of the game plan. I haven't seen Lane try. So presumably the floor will be shorter tomorrow because we're just going to be postponing.
And we have another small amendment.
And I know that, but we'll just, the whole thing will be postponed.
Yeah.
Including this
I didn't know.
technical
Missing
amendment.
much. Yeah.
And so, we'll take, so tomorrow I'm trying to line up, or will momentarily with Kayla, line up testimony from some individuals. And we may need to then also have testimony on Tuesday. I'm not going to ask folks to come in on Monday for this because, again, I think we have the time. But I will be asking for somebody from the Vermont League of Cities and Towns. I already have Billy Clark. I'm going to reach out to every town. I'm going to reach out to Chris Bradley to let him certainly come back in. And we can ask the clerk's office to send somebody as well, and we'll take the testimony and see if this will fly. Because I think we have time.
Great.
Are we cool with that?
And,
So, yeah. So with that, we'll be adjourned until tomorrow, shortly after the floor, which again should be, I think, shorter now, or is there a bunch of other stuff? What's it look like?
There's a decent amount of bills, but they're all fairly simple. Yeah, I can't imagine we're going to be on the floor for more than an hour.
So we'll probably have Billy Clark in at 11. That's the only person I've reached out to so far.